If you want to lead, that's how you lead.
I'll just stop the video because I am interested in.
Okay, sure.
Going.
All right, and now we have Ms. Lopez for the case number 3. So, Mr. Thanasides, you're up.
Thank you. May it please the court. Paul Thanasides on behalf of appellants. Earl Christine David Constable. With respect to the summary judgment entered in favor of Davis, the primary purpose or primary reason announced by the court was the same, that there can't be a conspiracy because there's no underlying tort. The only claim brought against Mr. Davis is conspiracy.
Excuse me. His case was basically right along with the others, right? Up or down. Let me raise something with you, Mr. Thanasides. This is perhaps an overly technical matter, but you know what? Sometimes we get this. That's why, you know, my staff attorney and I have looked through the record. We cannot find a final judgment in favor of your client. I know it got a little confusing there. He was allowed to join in on the motion for summary judgment, but there are final judgments in favor of the other 2 appellees, but not yours. And it suggests to me that you know, we don't really have we don't have fully realized jurisdiction until such a judgment is entered. And, you know, we could look at this as a premature appeal until then, which is perfectly fine, but we're going to need that judgment. So I'm just giving you this heads up. You need to go, you know, get one from the trial court. We can relinquish, but I'm not sure we even have to.
Were you were saying to no judgment against my client? I think maybe you were referring to Ms. Lopez.
I'm sorry, and no judgment in favor of of Davis. So you don't have at this point a final judgment that supports your appeal as to Davis.
I thought we did. I'm sorry.
Yeah. What you attach to your notice of appeal says, you know, it's the order allowing him to join into the motion for summary judgment. Okay, but there's no judgment. There's a judgment as to the other 2, but not as to him. And I think it's a technical matter. I think you go back to the judge and you say, you know, judge, you need to enter this judgment in favor of Davis. Go hence without day or whatever, based on the previous summary judgment ruling. But we need that. It sounds like angels on the head of a pin, but we need that.
I understand. And if it turns out that there has been one, is there some way that I can provide it to the court?
Yeah, I think what you do is you, send us a copy, send it to the clerk, or get the lower court clerk to send a copy of that judgment up, like a certified copy. But, you know, based on, I looked at the notice of appeal again yesterday, and it's not a judgment attached to that per se, and we couldn't find one in the record. It might be there, and we just haven't come across it, but it's not really referenced in your briefs as such.
My recollection, and this is just a pretty vague recollection, is that we filed the appeal at an abundance of caution before we actually got it. And then we got
and then that judgment never came. There are judgments as to the other 2 defendants, but not as to Davis.
I'll check.
Ms. Lopez, is that, and I'm not counting this time against it. Is that basically how you see it?
Your Honor, I actually think there is a final judgment. I'm looking for it now because I don't want you to get caught up on this issue either.
Well, no, I get, okay. Well, if you
combined,
if you can find it, you know.
I'm looking for it now, so hopefully by the time I speak, I'll be able to point you to the record.
Okay, or just send us a letter saying, you know, here's the page or whatever, but we couldn't find it.
Thank you. I will look.
Thank you. Okay, Mr. Thanasides, I'll restart your clock.
Okay, well, just in case we do have a final judgment, then what I will argue to the court that's independent and distinct with the Davis motion. Davis motion joined in the other motions, as you know, and then made an argument that was additional to the other arguments made in the Pisarcik and NFLA motion. And that argument was that as a matter of law, because Davis was acting as the agent of Bolden, that he cannot be liable for tortiously interfering for conspiring to tortiously interfere with the NFLAA. That's the unique argument for the Davis appeal. And there was no evidence. It was just a matter of law. As a matter of law, there's an absolute privilege that an agent can't ever be held liable for conspiring with a third party to interfere with the principal's contract. But I don't believe that is the law. And I think when you look at the O.E. Smith Sons case, it's 545 Southern 2nd 298. What it says is the privilege of an agent to interfere with the contract of his principal is divested when the defendant acts solely with ulterior purposes and the advice to terminate is not in the principal's best interest. It is for the trier of fact to determine whether at the time the inducement was made, it was for the furtherance of the corporation's interest or for George's personal interest with no benefit to the corporation. So it's not an absolute privilege like the other privileges that we've been talking about, the financial privilege, the not a stranger privilege. All of those privileges are all qualified. And in this particular instance, what you have to show is that you were not acting with ulterior purpose and the advice to terminate was in the best interest of the principal. That's what you have to establish to get this this privilege and make sure it's not divested. And that wasn't in the motion, right? There's nothing.
But basically, if I understand it, if the ruling was that there was no tortious interference as a matter of law, then Davis can't be. He's not. You haven't alleged his tortious interference. You've alleged his participation in the conspiracy. Correct.
That's correct. So his liability hinges on the underlying tort. So if you were to reverse with respect to the NFLAA, you could reverse with respect to Davis. However, Davis would say, well, no, you should affirm with respect to us, even with the reversal of the NFLAA's order, because I was acting as Bolden's agent and therefore have an absolute privilege as a matter of law to conspire with a third party to interfere with my principal's contract. And Davis cites a couple of cases that are outside of the jurisdiction. The problem with the logic of those cases and the logic generally of the idea that a principal or an agent can't conspire to interfere with the contract of his principal is that it's asserting the wrong, it's assigning the wrong claim, imputing the wrong claim. And what we know is that conspiracy, all it does is create joint and several liability for the underlying tort. It imputes the underlying tort into the co-conspirators, right? So that the co-conspirators are now liable for that underlying tort. And the question here is, what is that underlying tort? The underlying tort is not Bolden's interference with his own contract. If that was the underlying tort, then Davis couldn't be liable for conspiring to commit that underlying tort, because there is no underlying tort for Bolden to tortiously interfere with his own contract, or for Davis to tortiously interfere with his own contract, or the contract of his principal. Well, there's in the law that I just read you, there are certain circumstances where Davis can be liable, for tortiously interfering with the contract of his principal, and that's why it's not an absolute privilege. But in any event, that's just the wrong tort. The tort that's being imputed to Davis is the NFLAA's tort. That's the tortious interference. The conspiracy with the NFLAA causes that tort to be imputed to Davis. And Davis doesn't have any privilege to escape liability for that tort. And so that's the fundamental logic problem with the argument from Davis, is just imputing the wrong tort. And I would submit to your honors that if you please read the motion for summary judgment, you'll see that it's just asking for a ruling that as a matter of law, an agent can never be liable for interfering with the contract of the principal. And the O.E. Smith Sons case just says that, no, that's not the case. There are situations where that privilege is divested, and it's when the defendant acts solely with ulterior purposes and the advice to terminate is not in the principal's best interest. And in this particular case, we presented evidence that the jury could use to find that Davis acted solely with ulterior purposes and the advice to terminate was not in his principal's best interest. That's assuming that we're asking Davis to be liable for the tort of interfering with Bolden's contract with Christie. So that's not what we're doing in this case. It's even further removed. Remember, we're just asking Davis to be imputed liability under the civil conspiracy theory for the NFLAA's interference, which is actionable. So I'll reserve my 5 minutes for rebuttal.
Ms. Lopez, did you find that order?
I didn't find it yet. I wanted to listen to Mr. Thanassides' argument.
Yeah, I thought that made sense. Okay, we'll discuss that at the end of the case, at the end of the argument.
Thank you very much. May it please the court. And can you hear me all right? I know it sounds like Judge Northcott may have had some trouble before. So I just want to start at the...
Let me tell you, there are workers outside my house running a radial saw. So that's why it's fun.
Sometimes I have a little trouble with my connection, so I wanted to make sure.
No, I'm good.
At the outset, I just wanted to reiterate what was just discussed with Mr. Thanassides, which is if the court finds that there can be no underlying tortious interference claim against the NFLAA, then Davis cannot be liable for civil conspiracy with that. I think everyone agrees to that. And so I do not want to retread old ground, but this is my first opportunity to talk to you. So I want to talk about a few of the issues on that claim. And I understand where I think sort of the fallacy that exists in Constable and Christie's argument is to analogize this to a real estate brokerage contract, or that this is just a commission earned. They just make the introduction and then they've earned the commission. And any time where you go around them and try and circumvent this falls into that same sort of bucket as those real estate cases. And I would ask the court to look at the consulting agreements. These are not those types of agreements.
Well, and like come back to, the real estate commission. Sometimes those real estate contracts require, that they find the prospect, and some of them require that they have a closed sale.
But this is different, certainly, Your Honor, absolutely.
And but in either case, the buyer and seller can be, zapped for trying to go around the broker. Correct.
Absolutely. But this is not that kind of contract. This is a services contract. If you look at this contract, it doesn't say we will make an introduction.
All the more reason, in my view, because the services are to be given to Bolden, not to the NFLAA under their consulting agreement.
I don't believe that the record supports that finding, Your Honor. The services that are going to be provided under Section 2 of the consulting agreements says the company will provide ongoing affiliation liaison and advisory.
Affiliation liaison.
So it's contemplating, and this is consistent with Mr. Pisarcik's testimony, that they're going to be working with the affiliated entity, that they're going to be doing the things that they told Mr. Pisarcik they were going to be doing, 1-800 numbers, focus groups, those types of things. This isn't make an introduction, you've earned your commission, and you're out the door. And it's also not like a real estate agreement because it doesn't say once this affiliation is established, you have earned all your compensation and you get X amount. It instead says it's terminable at will. You have to keep providing these services. And at any time we can say, we don't want your services anymore. And at that point, what we have to pay is 30 more days, is an additional 30-day period. And so that's not what happens in a real estate contract. You earn it whenever you earn it. You earn it when the deal closes, or you earn it when you make the introduction, when you become the procuring cause. And your right to that full commission vests at that point. This is a services contract. And
what they have alleged is, but for the tortious interference by the defendants in this case, that relationship would have continued.
Your Honor, this is the NFLA can say, this is the interest that the NFLAA has in this deal. We don't want to be involved in a deal where these guys are going to be our affiliation liaison.
Right.
But
But instead of just walking away, they induced, this is the allegation, they induced Bolden to terminate these people.
Sure, but it's a terminable at will contract. And so they certainly have the right to say, and there's case law cited in our briefs, this is sort of similar to the Weissman wine sales case or the Ferris, case that involves the stadium where they say, we want you to fire your lawyer. And they say, well, it's an at-will contract. So they can say, we want you to fire your lawyer. They don't, there's no expectation that that's going to continue. So they can say, we don't want to do the deal. We have an interest in this deal. We have an interest in not being affiliated with them. We have an interest because we don't think they're qualified to provide these types of affiliation liaison services, which is, I think, very consistent. I know Mr. Thanasides suggested that rationale has changed over time, but I think if you'll look through every
That would become a jury question, would it not?
I don't believe so, because it's an interest. It's a legitimate business interest in saying, we don't want to be affiliated with them. We don't like them. You can have malice against them and say, we just don't like them. And we're not interested in entering into an agreement where we endorse your facility if these are the people who are going to be providing the affiliation liaison services, particularly if it's going to potentially interfere with the financial viability. So they've put forth legitimate business reasons that they don't want Constable and Christie to be involved in the situation. And the NFLAA can say, okay, well, under these circumstances, we have a terminable at will contract. I understand that they could have continued pursuing, I don't think the record will support successfully, but I understand that's an issue of fact, affiliations with the NFL Hall of Fame or the NFLPA, but Bolden has a right to say, I don't want that. Under these circumstances, I'm no longer interested in continuing this at will contract. The consequences of that are, the contract contemplates what will happen. There's 30 more days I have to pay, and then I can go forward and deal with the NFLAA directly. And so this is not like those real estate commission cases where the commission is fully earned and you go around their back and say, they've already done everything they're supposed to do. And you go around their back and say, no, let's just close the deal without them and pay the commission. Because this isn't a commission-based contract. The payments are defined as commissions, but they are payments for ongoing services. And under those circumstances, the NFLAA does have an interest, a legitimate business interest in saying, we don't want to do the deal under these terms. And once you're in the scenario where you're dealing with an at-will contract and a legitimate reason to do it, there cannot be a tortious interference claim against the NFLAA. They're not a stranger to the deal. They've put forward evidence of a legitimate business reason that they wouldn't want to do the deal. And under all the case law that all of us have cited, that is a legitimate, there's no ability for them to be liable for tortious interference under those circumstances, because it's an at-will contract. There's very limited circumstances when you can tortiously interfere with an at-will contract, particularly when you have an interest, when you're essentially a party to the relationship. And so I would say that is the critical and very important distinction of why these cannot be treated the same as these real estate contracts. Because, for example, it's not just that portion of Section 2 that shows that this is an ongoing services contract. It also says that the services to be provided by the consultant here under are exclusive. The consultant may not provide services to other clients in the same or similar assisted living development field. It says the consultant shall devote such time as is necessary for the efficient and expedient provision of the services herein agreed to be provided to the company by the consultant, and shall act at all times in a diligent and faithful manner in the best interest of the company and in accordance with applicable laws. It goes on to state that they need to maintain whatever type of registrations or relationships or memberships that may be necessary for them to provide these ongoing services. If their contract was just for them to make an introduction, none of this language would be necessary. This just simply isn't a situation where they are making an introduction, fully earning their money and getting out the door. And under these circumstances, the NFLAA certainly had a right to say, we don't want to do a deal involving these guys. And so let me look at my notes. I would say that that's the main point that I wanted to make as far as that, because I know it's been well argued. I certainly want to adopt Mr. Yagoda's arguments and say that under these circumstances, the NFLAA, the trial court properly found that the NFLAA could not be liable for tortious interference with an at-will contract under which they were not a stranger to the deal. I would also say that there, we've briefed it extensively, but there is not evidence to support. I don't think you need to reach the issue of improper motives, and I don't think you need to, or improper conduct. But if you look at that, there is no improper conduct that caused the breach. They're talking about conversations that were going on between Davis and Davis, who was Bolden's agent, and Pisarcik, at which point they're saying that Bolden had already decided to breach. So the improper conduct, it can't just be that you say that there's been misrepresentations. There have to be misrepresentations that result in a termination of the relationship. And under these circumstances, I don't think you will find any improper conduct that goes to that issue. And certainly there is ample evidence of legitimate business reasons why the NFLAA would not have wanted to do this deal. So incorporating all the prior argument, not trying to rehash too much old ground, there is an additional basis that you could also grant summary judgment for Davis, even if you found that you needed to remand as to the NFLAA and Pisarcik. And that is because Davis was acting as Bolden's agent. Mr. Thanasides has said, well, that's not an absolute privilege. That's correct. I agree with that, but there are no allegations. There's zero allegations if you look through the third amended counterclaim suggesting that he was acting outside of his scope as an agent, that he was doing anything that wasn't solely for the purpose of advancing Bolden's interests. And in particular, if you look at it, almost all of the actions that are, or many of the actions that are attributed to Bolden, they say are done through Davis. So there's no allegation in the case that there's nothing that would have put at issue the question of whether or not there was a personal stake that would have removed him from that agency. But I know that Mr. Thanasides argued that that is not the conduct he's attempting to impute to Davis. And just for a little sort of historical background, the document that Davis initially filed in this case was a joinder to Mark Bolden's motion for summary judgment, which was very, very similar to the NFLAA's motion for summary judgment. It says, first of all, that there can be no, and the reason that Mark Bolden is not one of the parties who's here before you today is that there's additional claims that are still pending below as to Bolden and to Vallis. And so Davis joined Bolden's motion for summary judgment. That motion was very similar to the NFLAA's, but there was also an additional argument, which basically said, I, Bolden, cannot be liable for civil conspiracy to commit tortious interference because I cannot be held liable for tortiously interfering with my own contract. Everyone agrees to that. That's the Ethel versus Balter case and tons of other cases. You can't be held liable for tortiously interfering with your own contract. And so Bolden said, you shouldn't be able to use conspiracy, which the purpose of conspiracy, it's not a standalone tort. It just imputes the conduct of all the other players, all the other co-conspirators to each one, so they can all be liable for all the conduct. So it doesn't create a new cause of action, you're saying, and so you can't use a conspiracy claim to circumvent the immunity from suit I have on this issue. And so initially I filed a joinder, and as we got closer to the summary judgment, I realized that Bolden's motion didn't say, and Davis can't also. And I needed to close up that loop on the fact that that Davis is not a party to the underlying contract, but he is an agent. And so that Richard Bertram case that I cited does stand for the proposition that an agent can't be liable for tortiously interfering with the principal's contract. And so first, I would say that as a standalone basis, there's no allegation that Davis ever acted outside of his scope as an agent on behalf of Bolden. So there would be no basis for finding him personally liable. So full stop on that one. I agree that's a great basis for granting summary judgment to Davis. I understand Mr. Thanasides says, well, but he could be liable if he had acted for his own personal stake. There's no allegations of that in this case. The allegations are all that he was acting for Bolden on Bolden's behalf. There has been zero allegations until the summary judgment came up in defense of the summary judgment motion. Mr. Sanasude said, well, yeah, but there could be a personal stake issue. But in addition to that, full stop, he's an agent, shouldn't be liable argument. There's an additional argument that just as Bolden shouldn't be able to be liable for a civil conspiracy, to commit tortious interference because he cannot be liable for the underlying tort. Similarly, because Davis could not be liable for tortiously interfering with his own principal's contract, he cannot be held liable for conspiracy to tortiously interfere with that contract. And Mr. Thanasides has cited a number of cases that he says are Florida cases that recognize that wherein Florida recognizes that a party to a contract can still be liable for conspiring to interfere with their own contract. We just ask you to look at those cases. We distinguish them in our brief. But I would say that none of those cases address this issue head on. In almost every one of those cases, there's either a passing reference to conspiracy count where you can't really determine what type of conspiracy is alleged or against who, or the focus of the case, most of them are the same sort of real estate brokerage cases. And the focus of the case is whether or not the party who was not a party to the contract with the broker could be held liable to the broker on a conspiracy claim. There is not one case that addresses the issue head on and I would suggest that Mr. Thanasides and I have both scoured Florida law for this, but perhaps we missed something, but we've both been looking very hard and there's not a case that I have found or seen that addresses this issue head on and says whether or not a party to a contract can be held liable for extra contractual tort damages for conspiring to interfere with his own contract. But I would say that the Florida law on conspiracy suggests that there should be no such cause of action, because what conspiracy claim, the cases on conspiracy, we cited the Banco de los Trabajadores case and several others that talk about the fact that the conspiracy is just what I mentioned before. It's just imputing the conduct, the acts of all the other co-conspirators to all the conspirators. And even if you imputed all the acts of the NFLAA or Pisarcik to Davis, he still couldn't be liable for the tortious interference claim because he's an agent of a party to the contract. There are some cases that we cited from California. There's an excellent case we cited from California. It's the applied equipment case that has a pretty extensive discussion of this issue in it. Let's find the exact language. It says, by its very nature, tort liability arising from conspiracy presupposes that the conspirator is legally capable of committing the tort. A party to a contract owes no duty to refrain from interference with its performance and should not be bootstrapped by a conspiracy claim. We also cited the Hicks case from the Northern District of Ohio that says allowing a conspiracy claim under these circumstances would allow a party to restate as a tort what is nothing more than a breach of contract. We also cited the Corso case from the Middle District of Tennessee, which says it makes no sense for a party to say that a party conspired to induce himself to breach his own contract. That certainly makes sense and is consistent with Florida law on this concept, which says you can't there's no claim for tortious interference if the party is already predisposed to committing the breach. And so to say that you conspired to induce yourself to interfere with your own contract seems inconsistent on Florida law and on conspiracy. There are some cases that Mr. Thanasides has cited from other jurisdictions that do suggest that those jurisdictions do recognize claims like this. I would say that the better logic is the cases that we've cited from California, from Ohio, and the Middle District of Tennessee. So I would say ask the court to find, in the event that it finds that there could still be a tortious interference claim against the NFLAA, that Mr. Davis still cannot be, that the summary judgment in favor of Mr. Davis still should be affirmed, because first, he's an agent of Mr. Bolden's and there's no basis for finding that he had a personal stake that would remove his privilege. And second, because he cannot be liable for the underlying tort so he should not be bootstrapped into that tort through a civil conspiracy claim. Unless the court has any other questions, I would rest on our briefing.
Let me ask you this, Ms. Lopez. You pointed out that the complaint does not allege that he had this personal stake, correct? Would they, if they have alleged his liability, do they need to allege that personal stake, or is that a matter of proof on the summary judgment record? And I'm asking a compound question here. If it's a matter of proof on the summary judgment record, if we're under the historic summary judgment standard in Florida, that would be your burden to prove the absence, correct? Of the personal stake.
Yes, Your Honor. Yes, Your Honor.
Under the new version of the summary judgment rule, maybe not.
I would say it's just not, that issue would have to be something that was framed by the pleadings for us to have an obligation to come forward with it. That I'm just looking for one of the cases that basically another case that talks about
This personal stake has to be alleged in the complaint, you're saying.
That's my position, Your Honor.
Okay, that's all. Okay. Okay, your 20 minutes are up. And we'll now hear from Mr. Thanasidis to rebut.
Your Honor, I believe the lack of a personal stake, or those aren't the exact words for the exception to the qualified privilege, but I believe that would have to be asserted as an affirmative defense, and then we would submit a reply to that. The complaint itself just alleges the liability, and not necessarily every
short and plain statement of the facts, is required, given rise to the liability.
Yes, and so look, I want to address the first thing, Ms. Lopez. One of the first things she said is that the record doesn't support that that there was no continued involvement between the NFLAA and the Christian Constable because of this language of the ongoing liaison. The ongoing liaison language, if you look at the actual record, what it says, what Mr. Davis, Ms. Lopez's client, testified to is that ongoing liaison activity was focus groups and referrals that Constable and Christie were going to do on behalf of Bolden, not on behalf of the NFLAA. Had nothing to do with the NFLAA. And if you look at Constable's affidavit,
the agreement says provide to the company ongoing affiliation liaison. It doesn't say that they would furnish any services to the affiliated, the NFLAA or any of the other NFL associated, right? So these services are specified to be provided to the company being Bolton et al.
Bolden, correct.
Bolden.
That's exactly right. And the testimony and then the affidavit of Constable also confirm that it was services that Constable and Christie were going to provide for Bolden. And then Constable's affidavit says all of those services, we would not involve the NFLAA at all. This was just about them contacting their friends and setting up focus groups because they have contacts with players. And they would do that for Bolden. It had nothing to do with the NFLAA. And so
what about the statute of frauds here? This is a services contract to be performed more than a year. So Mr. Davis's interpretation is immaterial. This clearly says an affiliation means the written endorsement of the company, Bolden's company, by these affiliations, in this case, NFLAA. This is an ongoing service agreement whereby they have to obtain a written endorsement for each ALF, and this contemplates at least 32 or 33 ALFs, and a contract of which cannot be performed in less than a year. So we can't rely on Mr. Davis's extrinsic evidence and hearsay about the interpretation of this contract. So your clients were to obtain written endorsements, correct?
Yes, and they did that with the NFLAA.
They did. They obtained a written endorsement.
What the contract turned into was what's called a strategic affiliation agreement.
And you're saying that they made that happen?
Yes, they introduced Bolden to Pisarcik and Davis to Pisarcik, took them on a tour of the facilities, brought them down, wined them and dined them. And then when they finally got to Davis and Pisarcik got together, they started to conspire to cut him out of the commission. But that they are the ones who made the introduction and created the relationship and sold Pisarcik on the idea initially. It wasn't just a phone call. I mean, they brought him down, they flew him down, they had dinner with him, they took him on the tour of the facilities, they went up to New Jersey and met with him. They sold Pisarcik on the concept of branding these ALFs. Now remember, the first initial idea here was they were going to go chapter by chapter, because that's where my guys had the contacts, was in the chapters. They were going to go chapter by chapter to get the endorsement of those ALFs. That was the initial contemplation of the consulting agreements. What Christie and Constable did is they realized they could get into the national headquarters pretty early on. They had a couple of endorsements of the NFLAA chapters, and they said, we can take this and go right to the headquarters and we can get all of them in one fell swoop. And that's what they did. And they brought down Pisarcik and
Yeah,
sold
but you
him on
keep
that
saying they did when Joe Pisarcik made it very clear that he did not want to deal with them in any way, shape, or form at all.
Yeah, and what the jury
And this may
would
be a question of fact, but let's get to the truth of the matter. Your client
Yeah.
simply introduced them. They didn't obtain anything.
Well, they did more than just introduce them. They sold Mr. Pisarcik on the concept.
Okay,
When
so
Mr. Pisarcik-
now you're telling me they got involved in negotiations when earlier you told me they didn't.
No, I'm telling you, they were salespeople for the concept. So they went to
Well, this goes to Ms. what Lopez is saying. This isn't a real estate contract where the commission is set once they make the meeting. These guys were responsible for getting an endorsement for each and every ALF, no matter how many years it takes. This is not
And they
selling
could've-
one house.
And they could have done that with the NFLAA, the NFLPA, or the Hall of Fame. And so the NFLAA didn't have the right to say, you know what, I'm going to make a misrepresentation that's going to cause Bolden to terminate. Because that's what they did. If you look at the May 21 termination letter, the termination from Mr. Bolden specifically says, I was told by Mr. Pisarcik that you have no relationship with anybody at the NFLAA, and therefore I have cause to terminate. That representation was untrue. That was a misrepresentation that Mr. Pisarcik made to induce the termination. That's improper means. And that's, we've kind of missed that a lot because everybody keeps talking about the motive, the why. But remember, the Churchala case says it's not just the justification, it's are you justified in interfering in the manner in which you are interfered? And so improper means is something we have to evaluate and say, did they establish an absence of disputed issue of fact as to improper means? And
Time for us to wrap this up, Mr. Thanassides.
thank you for your time.
Thank you both. And I'll tell, I see Mr. Yagoda still hanging around. So in order to leave, you press the leave button, it's aptly named, and you'll go off into the ether and disappear from our virtual courtroom.
Thank you
All right.
both. Well argued.
Thank you very much.
Thanks a
Can I
lot,
ask just
guys.
one question about that final?
Oh, yeah. Let's come back to that. You did not find
I
it?
haven't found it yet. I was just starting to
Okay.
look for it, but my computer.
Here's the
froze.
thing.
If you do find it, how do you want us to get it to you?
Well, some little gremlins who are like called staff attorneys who have been watching this. Somebody emailed me and said, I think emailed all of them, said, if you find that order, you need to get the clerk of the lower court to supplement with it, to send it up. And they'll send a, properly stamped. And if you can't find it, we need to get one entered by the judge. And so, give us what you need. Maybe if you don't come up with it like in 5 days, file a motion with us to remand for the entry of this order. And this because in the meantime, if it hasn't been rendered, this appeal is premature and can become mature when that order is rendered.
Thank you.
Okay.
Thank you very much.
Got it? Thank you both very much.
Thank you. Have a good day.
You too. And with that, we are adjourned. Thank you.